have discussed a few topics since we started. As I said, we started during September, Wills Week. We have discussed what happens if you die without a will. Why is a will important? We've looked at who are the parties to a will, parties like your executor, your heirs, your beneficiaries. We've also looked at guardians. We've looked at what makes your will valid or invalid. We've also covered the difference between a will, a pension fund, and insurance policies. We've looked at how do you protect your loved ones, especially your children. We've also looked at the cost of dying in South Africa, as well as last week, we then looked at the effects of your marital system on your ability to allocate your assets. Today's session, as I indicated, is on the administration of estates. Okay, I see somebody is saying there's no sound. I am can you give me an indication if you can hear what I'm saying? Can everybody hear? Okay, all right. So, as I've indicated, we're going to be talking about the administration of estates today. Before I continue, let me just let you know that today I have tried the wonderful world of Facebook. We are live streaming the session on Facebook. If there's somebody who wants to join us but cannot, because I think there's already 54 people. If we reach 100, people will not be able to get into Zoom. So you can let them know that they can go to my profile on Zoom. They can just type Ginele Mabapa, and that's where they will be able to get what we are discussing today. My name is Ginele Mabapa. I am an attorney and a notary by profession. I'm also the author of a book entitled Before, During, and After the Wedding, which is a book on the legal implications of marriage in South Africa. It basically tells you what is it that you need to do before you get married, what is it that you need to do during the time that you're getting married, during your wedding itself, and what are your rights and responsibilities once you have been through your wedding. It goes on to tell you what happens in the event that your marriage ends. We know that marriage ends, whether we like it or not, we're all going to die. So when you die, your marriage ends. And sometimes, unfortunately, it ends through divorce. So all of those things are covered. I cover all types of marriages, whether it be customary, whether it be civil marriage or a civil union. I also talk about cohabitation. So the book is available. I will give you the details at the end of the end of the session. So today we are going to be discussing the things that you said you need information on. And that is what happens to your assets after you pass on. Before we begin, I just want to highlight a few things. And it is the fact that when you pass on in South Africa, or when somebody passes on in South Africa, their estate is frozen until an executor is appointed. What that means is that nobody can withdraw funds from their accounts or do anything with their assets until an executor of the estate has been appointed by the master of the High Court. Those of you who have had deaths in your families, you might have experienced what I'm talking about. That sometimes when you go to the bank, not sometimes, when you go to the bank, you report that your family member has passed on. the bank will immediately freeze the accounts, and you will not be able to withdraw money from the accounts. They will tell you, bring the letters of authority, okay, in order for them to be able to do anything with the, in the account of the deceased. The freezing of the assets is done so that their financial affairs should be wound up. That is, that debts should be paid. The fact that you have, somebody has passed on doesn't mean that their debts should not be paid. They will still need to be paid, okay? And whatever is left should then be given to the beneficiaries. There is somebody who keeps saying that there is no sound. Is that the only person, or are there other people having problems with sound? Because from my side, it seems as if everything is okay. Should I go on? Okay. All right. So whoever you're having problems with sound, please check your computer or your whatever device you're working on, because everybody else can hear what I am saying. Okay. So as I was indicating, the assets are frozen so that the estate should be wound up and the debts of the deceased should be paid, and whatever is left should be then be given to their beneficiaries or their heirs. So how do we make sure then that the assets are dealt with? The law says, the law that deals with the administration of estates, it says that once a person passes on, their spouse, if they are married, if they're not married, their family, it would be their children. If they don't have children, their parents, and so on and so on. Basically, their family should report the death to the master of the High Court within 14 days. Now, how do you report to the master? There are forms that need to be filled in, and there's documents that need to be submitted to the master of the High Court. Without these documents, without the forms being completed, the letters of executorship or authority will not be issued out. So it would be the same as you not having reported. The documents that need to be submitted to the master is the original or certified copy of the deceased death certificate. I suggest that you submit a certified copy of the death certificate. If the deceased was married, you will have to submit a copy of the marriage certificate. If the deceased had a will, then you will have to submit the original copy of the will to the master of the High Court. The master will not accept a copy of the will. If you don't have the original will, you want the copy to be submitted, you're going to have to go to court and get the court to order the master to accept the copy. Now, the forms that need to be completed, remember, you are reporting the death of someone. So the first one is a death notice. With a death notice, that's a form that you use to indicate the details of the deceased, including when the deceased died. And in that form, you'll also be giving details of the, of their marriage, their spouse. If they have children, you'll be listing all the children that the deceased had, whether those children are still alive or not. If the children have passed on, you'll need to indicate whether at the time they died, they had children or not. Okay. And if at the time they died, they had children, you'll have to list those children. Okay. That's the first form that you're going to complete. The second one is a next of kin affidavit. This affidavit discloses the relations that the people who are reporting have with the deceased. Okay, so if it's the wife, then the wife will be indicating, or the husband, sorry. When I refer to the wife and husband, I'll use the term spouse so that I don't come across as being biased towards a particular gender. Okay, so the children will also be listed in the next of kin affidavit. So if you have a spouse and children, that's all you list. If you don't have if there's no spouse and children, then that's when you start listing other relatives of the deceased, like the parents, and so it goes. The other form that needs to be completed is an inventory. An inventory is nothing more than a list of assets the deceased owned at the time of their death. Okay, and the value of those assets. So you need to list them, all of the immovable properties, all of the movable properties, you need to list them. You also list, if there were people who were owing the deceased at the time of his death, then you list those debts that were owed to him, not that he owed to other people, but debts owed to him, where he was a creditor to other people, you list them. The other thing is you need to submit an affidavit which confirms that the estate has not been reported to another master's office. When I was saying that you report the death to the master's office, you report not to any other master's office, but in the area where the deceased was living. For instance, if the deceased was living in Polokwane, you report to the master's office in Polokwane, not the master's office in Pretoria. The other affidavit, sorry, the other is a declaration of marriage. Okay, so you need to indicate there that how was the spouse married? For instance, if the spouse was married to other people, you need to be able to say that. If the deceased was not married, you indicate that he or she was not married. Now, the other thing is, there's a form where you have to indicate what's this? Sorry, it's not, sorry. There's a form, it's called a nomination form. This is the form wherein, if there is no will, all of the people who are supposed to benefit, say for instance, the deceased had a spouse and children, those people have to nominate an executor. So the form has to be completed and signed by all those people who are going to be benefiting from the estate. The other thing is, the person who's nominated has to then complete a form called an acceptance of master's directions or executorship. That form is an indication that the person is accepting the nomination that has been made for them to become the executor. I forgot when I was talking about the documents that need to be submitted. One of the other documents that needs to be submitted is the identity document of this person who will become the executor of the estate. Okay. So once all those documents are submitted, the master will then appoint an executor or a master's rep. Okay. If you have a will, the master will appoint the person that you have nominated as your executor in the will. If you do not have a will, the master will most likely appoint the person that has been nominated, by your beneficiaries as the master's rep or the executor. Now, there is a difference. If an estate is below 250,000, the master will issue what we call letters of authority. And this letters of authority is issued to the master's rep, who then has the responsibility to pay whatever debts are there and distribute the remainder of the assets to the beneficiaries. Okay. This is the easiest form of appointment because that person does not have to do a whole lot of things. But once the estate is worth 250,000 and above, then the master will issue letters of executorship, and those letters, that letter, it's only a letter, but we call it letters of executorship. So once the executor is appointed, normally what the master will do, if a person is not a professional dealing with estates on a normal day-to-day basis, the master will advise the executor to appoint an agent who will then help the executor to administer the estate. The agent normally would be people like me, attorneys, who will do the job. It could be other professions also. Yeah. So the executor, it sometimes happens that because you did not have a will, people have to nominate, that there's a dispute. You would find that people are not necessarily wanting to choose one person. Maybe everybody wants to be chosen as the executor. Then the master will have to be involved there. Normally what happens is if a person was married, the master will give their spouse preference as the executor of the state. If there is no spouse, then the beneficiaries will become nominees. Okay, they will choose one of them or choose all of them, depending. But master also has a discretion not to choose any of the people who are there, okay, and choose somebody else. Okay, but that would happen, it would be an extreme case. What normally happens is that the master will choose amongst the beneficiaries. Okay. So what is an executor? I mean, you've heard me talking about the executor. A lot of people talk about the executor. The executor is nothing more than a person who steps into the shoes of the deceased. Okay, this is the person who is charged with the responsibility of administering the estate. Once a person passes on, their role is to pay the debts that the deceased had before he passed on, as well as to ensure that the beneficiaries get what is due to them from what is remaining in the estate. Okay. So once he has done that, the executor will report to the master, and the job is done, will be relieved of their duties. Okay. Now, they have a responsibility to administer the estate. What is the process that they're going to follow? The executor will need to advertise the estate. The executor will advertise in the government gazette as well as in a newspaper that is circulated within the area where the deceased lived. Okay. And in that advert, the executor will be giving 30 days notice to the creditors of the deceased to lodge a claim against the estate. After 30 days, if there is no claim, then he will do a liquidation and distribution account, which will consist of the assets of the deceased, the income received since the deceased passed on, the liabilities of the deceased, any cash in the estate, and also give an indication of who will the estate be distributed to. Remember, SARS also needs to be paid. So that indication will be there if there is any money that needs to be paid to SARS. Now, during the time, sorry, in between the advertisement as well as the drafting of the liquidation and distribution account, the executor will get all of the assets of the deceased, make sure that they have control over all of the assets. One of the things that they will do is they will open an estate account, a late estate account, wherein if there's any monies that need to be paid, those monies are going to be paid into that account. Remember earlier I said that once you go to the bank and the bank, you tell them that somebody has passed away, they freeze those accounts. They unfreeze them by putting money into whatever money was in the deceased account. They will then put that money into the late estate account that the executor would have given to them. No money will go to anybody else except the executor, and it will be in the account, the late estate account. The executor will also, in that process, during those 30 days, they will be going to banks, to a whole lot of other institutions, just to make an inquiry if the deceased did not have some form of account or investment in those banks or insurance companies. Because remember, when we covered the difference between your will, your insurance, as well as your pension fund, I indicated that if you take out a pension and you do not nominate a beneficiary, what is going to happen is that that money is going to go into your estate. That's part of the reason why we even check out with the insurance companies if there's anything. What the executor will not do is to claim money from insurance companies or to claim from your pension fund. That is something that the beneficiaries do directly. Okay. So the liquidation and distribution account will be drafted, and once it's drafted, it will then be taken to the master of the High Court. The master will inspect the liquidation and distribution account. If the master is happy with the liquidation and distribution account, he will then give permission to the executor to proceed with the administration. Proceeding means that the executor is going to now put in a second advert. The first advert was to let the creditors know that the deceased has now passed on. They can then lay their claims against the estate. The second advert, it's basically to let people know that the liquidation and distribution account has been done, it's completed, it is open for inspection. So if people had an interest, for instance, some people had laid claims against the estate, then they can now go and inspect the liquidation and distribution account, they can either go to the master or to the magistrate's court, because the executor has a responsibility of taking the liquidation and distribution account to the magistrate's court, where it will lay for inspection for 21 days. So they will be able to inspect that. And once the 21 days is over, and perhaps there's no objections or anything, then the executor will now be in a position to make payments on the estate. Okay. Now, and the executor has about 2 months to be able to complete paying whoever it is that they're supposed to be paying. You will remember that the executor has to pay the master a certain fee. There's a calculation that needs to be made. The executor has to pay themselves. They also have to pay all the creditors. If you have a bond, for instance, the bond has to be paid off. If you have car installments, the cars have to be paid up, all of those things. And whatever is left, it then goes to the beneficiaries according to your will, if you had a will. If you did not have a will, it will go to your beneficiaries according to the law of interstate succession. Okay. Now, what if there's an objection? Because it happens that sometimes people lay claims against the estate, and the executor feels that no, this claim is not something that I will accept. I'll give an example. For instance, you will find that there's a claim, maybe the deceased had a spouse and had a will. In the will, they left their spouse out of the will. They did not make provision for the spouse. So the spouse perhaps would put in a claim against the estate for maintenance, because the law allows the spouse a surviving spouse to claim maintenance. So the executor might say, I'm not going to pay this maintenance. You do not meet the criteria. So in the liquidation and distribution account, of course, the executor, because they are deciding not to pay the claim, they will not include the maintenance of the spouse. In that case, then the spouse can lodge an objection. The objection, it has to be lodged within the time period that the liquidation and distribution account will be laying open for inspection, and that is 21 days, okay, from the date of the advert. Okay, the objection will then be sent to the master, who will then communicate with the executor saying, I have this objection against the estate, so against the liquidation and distribution account. Please give me a response to this objection. And the executor, of course, has to submit an explanation to the master. And they have to do that within 14 days of receiving the communication from the master. So if the master is happy with the objection that the executor has given, they will accept it and let the objector know. If they are not, if they are not happy with the response given by the executor, or they feel that the complaint has merit, the master would then either instruct the executor to amend the liquidation and distribution account, or give any other directive to the executor. Now, it might happen that the objector's objection is not accepted. If they are not happy, what they can do then is to make an application to the court and have the court determine whether that objection is valid or not. Okay. And it is then up to the court to make a decision that it sees fit. Okay, depending on the evidence before it. Okay. Now, let's just say there are no objections, or objections have been there and they have been dealt with. Now it is time to pay. Now, how and when will the beneficiaries be paid? Okay. I've indicated that debts have to be paid first. SARS has to be paid. Creditors have to be paid. Once they have liquidation and distribution account is laid open for 21 days, the payments can now be made to the beneficiaries. If you have a will, the payment will be made according to your will. If you do not have a will, the payment will be made according to interstate succession rules. Okay. For instance, if you have a spouse and you do not have children at all, your spouse will get everything. If you do not have a spouse, but you have children, your children will get everything that is left over in equal shares. So there's not distinction as to whether the children are minors, they are majors, whether they have disabilities, whether they are rich, they are poor, they will get the same amount of money. If, for instance, you've left 1 million for distribution and there's 5 children, each one will get 1 million. Now, if you have a spouse and children, there's a formula that is used. Your spouse will get a certain share from your estate, and your children will get the remainder. Okay. So now, if you have a will, sometimes it happens that in your will, the deceased indicated that I am giving maybe my house to one of my children, or I'm giving my, what can I say? Or an investment maybe at Old Mutual to my eldest daughter. Okay. Now that, and then after that, and saying the residue I now give to all of my children, okay, in equal shares. What that means is that the daughter will get the investment. It will be paid out before all of the others get what is left out to them. We refer to that as a legacy. So the daughter is a legatee. She will get the house or the investment that was left to them directly. And after that, the remaining amounts will go to the rest of the beneficiaries. Okay. One of the things that you wanted to know was what happens to the money or assets that are left to a minor child, a child who is below the age of 18. Well, it depends on what provision you made for your child. If you've left your will and you have indicated what needs to happen to the assets that you're leaving to your minor children, it will go according to your will. But if in your will you're saying I leave the residue of my assets to my children without making any specific provision, it is the same as if you died without a will. because the money or assets that are due so let me just stick to the money. Any money that is due to go to the minor child will be deposited into the guardian's fund, where it will be invested until the minor becomes major, they turn 18, at which stage whatever was in the guardian's fund will be paid directly into the account. Okay. So when the money is in the guardian's fund, what normally happens is that the minor or their guardian will be able to claim an allowance. They can apply for payment of an allowance to pay for school fees or living expenses. But note, school fees, the master will pay them directly. I think the master will pay them directly to the school. But for living expenses and school uniforms and whatever, you can make an application for the master, to the master on behalf of the minor. Okay. I gave an example of a claim that can be made against the estate. There are certain claims that can be made against the estate of a deceased person. Two of them. One is the maintenance claim of children. The other is the maintenance claim of the spouse. Okay. I've already talked about the one of the spouse, where you have a will, you've left out, or even if you don't have a will, but what is due to the spouse is not sufficient. The spouse can make an application for maintenance against your estate. Okay. And it's not all the spouses that can make application for maintenance, or even if they make application, it's not any spouse who will get it. It will be those spouses who cannot afford to take care of themselves, and the estate has enough to be able to take care of their needs. Okay. Then when it comes to children, most people are not aware that your responsibility to maintain your child does not end at your death. Okay. So you still have a responsibility. There are people, so for instance, who will draft a will and live out their children. And you'll find that the children are minors, maybe they are below the age of 18, or even if they are above the age of 18, they are still at school, they are not self-sufficient, or they are unemployed. Remember, as a parent, your responsibility to maintain your child does not end at the age of 18. It ends when your child is self-sufficient. So your children can make a claim against the estate. Okay. The other that I need to warn people about, I know there are people who have maintenance orders against them, and whilst they're still alive, they decide not to pay maintenance. Guess what? You die, and there's a maintenance order against you made by the court. That maintenance order is a credit against your estate. Your child or their parent will go to the executor with the court order and make a claim for all the maintenance you refuse to pay whilst you're still alive. So if your maintenance what's this order is what? let's say 5,000 a month, and it accumulates interest every year, and you have not paid maintenance for 10 years, that calculation of the 10-year debt is going to come in, and your estate is going to pay that amount. The implications of that is that sometimes you might find that your beneficiaries get nothing, depending on how much is left on your, in your estate. So yeah. So those are the claims that can be made. And I think for today's session, I will end there. And I see in the chats, there's a bit of questions. So I'll attend to the questions. There's a question from Tatong Kosi saying, what happens to the monthly repayments like bond while the estate is being bound? Is the remaining spouse still liable in case of joint bond? Your debts, they continue as normal. They still the responsibility to pay those debts. If you don't pay the bond, the banks will do what they normally do if you default. Okay. But it is important to let them know that the estate is being administered, and the executor to communicate with them, letting them know the progress. So what happens if the deceased is married to two spouses who will be responsible for handling in the estate in case there is no will? Normally, both would be appointed as executor. If there is no agreement between the two of them as to who should be the executor. But remember, they would not necessarily be the ones who are administering the estate. They are going to have to appoint an agent who will administer the estate on their behalf. That was a question from Anna and Makabo Sukobelo Ore. So the kids can be supported until he or she goes for pension. Not necessarily. The responsibility is until the child gets self-sufficient. We know that there are children who would not want to be self-sufficient, who are lazy. If you have such a child, then you can go to the court. Let's say there's a maintenance order against you. You can go to the court and ask them to be released from that responsibility. Okay. So Nanhlanhla says, oh, I'm struggling to hear well due to heavy rain. Is it possible to obtain the recording afterwards? Yeah, today's recording would be available. I hope it comes out nicely. We did not have lots of disturbances, so I think it will be available, unlike the other sessions. I understand the estate is combined when one spouse dies. What happens to debts like cars, bonds on the remaining spouse's name? Is it paid? All debt needs to be paid. It needs to be paid. The executor is the one who will pay the debts from the funds of the estate at the time that the estate is being administered. Remember, if the debts are not paid, nobody gets paid. The beneficiaries will not get anything. Okay, what the executor will do if, for instance, the spouse is unable to pay from their own funds, maybe they do not have the means, they're going to have to talk to the executor, who will look at the needs and be able to assist, provided there's something in the estate. If there's nothing in the estate, there's nothing that the executor can do. That was Kia was asking the question. Manari says, a plea to our spouses, please don't hide these kids. Let us know about them and maintain them. I agree with you, Manar. They must just make sure the kids are in the open. Because if they hide them from you whilst they're still alive, you're going to find out anyway when they've passed on. So I may just as well let you know. And at the same breath, I just want to say to those women, I know mostly it's men who have maintenance orders against them. And you'll find that they are married, but their spouse is refusing that they maintain the children. I just want to say to them also that you might think that you're spiting your stepchild, but the reality is you are spiting yourself, because once your spouse dies, if he dies before you, that child has a right to bring in their claim for maintenance. Benson Salakuva, I hope I spelled your surname correctly. If not, please forgive me. Which monies is the executor not allowed to claim? I only had pensions. Okay. The executor will take hold of all the assets in the estate. Your pension fund is not your asset in the estate, as well as the insurance policies. Those are not assets in the estate. Unless, of course, there is nobody who can claim, who's been nominated under your policies, then the money will get into your estate. Jerry Mamawolo says, can a live-in partner claim against your estate if you're single legally? Hey, yeah, that is a very difficult one. I think I talked about this last week. Currently, as a law stands, a live-in partner does not have the right to claim against your estate. However, we've had one case now where the Supreme Court of Appeal has held that they can do so. And the reason for doing that is that our law as it stands allows same-sex partners, live-in partners who are in a permanent relationship to claim, against the estate, or to inherit from the estate of their deceased partner. But it does not allow heterosexual live-in partners to do that. So the Supreme Court of Appeal found that it was discriminatory. But that case has now gone to the Constitutional Court. So we're sort of like waiting for the Constitutional Court to give us direction as to whether that will become law or not. Okay. So currently, as the position stands, no. But we're waiting for a formal final decision from the Constitutional Court. Melita Mukhashwa, without a maintenance court order, will an affidavit be acceptable for a child's claim? Okay, if there's no maintenance order, you can still make a claim for maintenance from the estate, but then you cannot claim backdated amounts, because there's no order for maintenance. There's no way to prove that this person has been owing maintenance. Okay, so the only thing that needs to be done is maybe if the executor does not believe that the child belongs to the deceased, there might be DNA tests done to determine that the child is indeed the child of the deceased. Who pays? Kutazo Muzanani says, who pays for the rates if there is no money in the estate account? Yeah, no. Whoever is living in the house will have to pay for the rates, because if you don't pay for the rates, the same thing will happen if, as if, let's just say the deceased was still alive and they did not pay for the rates. There will be claims against them. The municipality will switch off the lights, turn off the taps. But what is likely to happen is, if, from what you're saying, if there's no money in the late estate account, it would mean that the late estate is unable to even pay its debtors. If the late was married in community of property, the spouse will keep having the responsibility. Okay. If they were married out of community of property, the spouse will not have the responsibility, but the problem is debts have to be paid. So the likelihood is that that house is going to be sold in order to be able to pay the debts of the deceased. So it is important. I think when I was looking at the costs of dying in South Africa, I was saying it is important to ensure that when you have debts, you have insurance against those debts, so that when you pass on, your insurance will pay off, so that your estate does not necessarily have debts and liabilities that become a burden now on your beneficiaries. So Nonhlanhla says, what happens when a parent who is unmarried passes on without a will, leaving kids that are minors, and only to find that in a life cover, the beneficiary is a granny to the kids, however, also passed on before the parent could make changes. Applying for pro bono assistance also could not succeed. After 4 years of the passing of the parent, the elder child is above 18. Yeah, it gets very difficult for me to give an answer to this one, because I would have to know the circumstances. Okay. Again, what would need to happen? I think this would have had to go into the estate, because if the granny died before, then it meant that there was no listed beneficiary to the policy. So it should have been paid over into the estate. I suggest, Nonhlanhla, that you contact me directly, so that I can hear what your actual challenge is, and see if I can't be able to give you advice. Okay. Ellen Serapelo, Ori, I just joined. Where do I access the recording? I normally send out whatever is available. I'll be sending out to people who are in my WhatsApp contacts. I'll probably also paste it on Facebook, or you can get it from Facebook, since we are live streaming directly to Facebook. Tatung Gosi says, I think before you report the death to the master, you need to withdraw money from the deceased account or any joint account. It takes long to wind estate, and we still have to live and pay rates, else we will be kicked out of the house. Just my thought. Tato, it would be unlawful for you to do that, because the law specifically says that nobody is to touch anything until the letters of executorship has been issued by the master of the High Court. So as a lawyer, I cannot advise you to do that. Okay. I think we've covered all the questions. We've come to the end. Today's recording, I think I will be able to make it available. For those who are on my WhatsApp list, I will be sending the link to you. Those who are not, I'm sure you can go to my Facebook profile. You would be able to get it, or you could send me your contact details on 076-884-1842. That is my WhatsApp line. And I will be able to send it to you. You need to indicate who you are and that you would want the link to be sent to you. Those of you who want to receive invitations directly through WhatsApp, what you need to do is to save my phone number on your phones. Send a message to me asking me to include you on the list, and I will include you on the list. My phone number, WhatsApp number is 076-884-1842. Maybe let me write it down. I should have done it's on the under chats. I've put it under chats. Okay, and those who want a copy of the book, it's 275. If you live in Polokwane, you can fetch it from me, or I can deliver it to you. If you live out of Polokwane, you add 60 rands to that amount, and I will courier it to you. You send the request to the same number. As I indicated at the beginning, this is the end of the series that we started in September, but it is not the end of the sessions. I will be communicating other sessions that we will be engaging on. I had thought when I started that it was just going to be a Will's Week thing, but you have shown such an interest in the sessions, and a lot of you have asked me to continue. I will be continuing. I don't know whether I will make it a weekly affair or if it will be once a month, but there will be a continuation of the sessions. And I will continue pasting in the WhatsApp what's this broadcast, and also on Facebook. So thank you, ladies and gentlemen. We've come to the end, and goodbye. Where's that?